Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Yesterday, June 23rd, 2026, the Supreme Court dropped 5 opinions to close out the October 2025 term. 5 cases, 1 day. And when you line them up side by side, the patterns jump right at you.
Today, the full rundown: Blanche, Acting Attorney General versus Lau, immigration law, and the rights of lawful permanent residents; Cisco Systems versus Doe, a massive human rights lawsuit targeting one of America's biggest tech companies; ExxonMobil versus Corporation Cymex, a 60-year-old fight over Cuba and over $1 billion in seized assets; Landor versus the Louisiana Department of Corrections, a Rastafarian inmate whose prison guards forcibly shaved his head; and Pung versus Isabella County, Michigan, a family that owed $2,241.93 in property taxes and lost a home assessed at $194,400.
Now, we want to flag something up front. Today's episode gives you the bird's eye view, voting patterns, authors, key holdings, and what each decision means in plain English. Each of these 5 cases deserves its own deep dive, and we'll release individual episodes breaking down every opinion fully, so stay tuned for those. Today, the overview.
And one more thing before we dive in: the court may release additional opinions tomorrow, June 25th. This term still has room to surprise, so keep an eye on the feed. If more opinions drop, we'll cover them. Before we get into all of that, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report.
And if you have questions about these cases, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
All right, here's what you need to know. Let's start with the big picture, because this term closer tells a story about the court itself.
5 opinions, all dropped the same day. As you may recall from our interview with Dr. Adam Feldman in late June, the Supreme Court releases about half of its opinions. This year will be no different, hence the 5 opinions yesterday.
4 of them, 4 straight, split exactly 6-3. The same 6, the same 3, every time. The 6 in the majority: Chief Justice Roberts and Justices Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, the court's conservative bloc, voting as a unit. The 3 in dissent: Justices Sotomayor, Kagan, and Jackson, the liberal bloc, also voting as a unit. 4 cases in a row.
And the authorship pattern across those 5 majorities is notable. Every conservative justice on the court wrote a majority opinion yesterday. Justice Thomas authored Blanche. Justice Barrett authored Cisco. Justice Kavanaugh authored Exxon. Justice Gorsuch authored Landor. Justice Alito authored Pung. 5 conservative justices, 5 majority opinions, all in one day. And Chief Justice Roberts joined every single majority, not one authored opinion. He rode shotgun all day.
What about separate opinions, concurrences, and dissents?
Here's where it gets interesting. Justice Jackson led the pack. She authored 3 separate opinions across these 5 cases, more than anyone else on the court yesterday. 2 full dissents, one in Blanche, joined by Sotomayor and Kagan, one in Landor, again joined by Sotomayor and Kagan. And in Cisco, she split the difference, filing an opinion that concurred in part and dissented in part, joined by Kagan. She agreed with the majority that the Torture Victim Protection Act doesn't cover aiding and abetting liability, but she broke hard from the majority's decision to shut down the Alien Tort Statute framework entirely. So Jackson agreed on the narrower question, but wouldn't go as far as Barrett's majority took it.
Justice Sotomayor was busy. She authored 2 separate opinions: one full dissent in Cisco, pushing back on both the ATS ruling and the TVPA question, joined by Kagan and Jackson on most parts. And then in Pung, the near-unanimous case, Sotomayor crossed over and filed a concurrence, joined by Gorsuch and Jackson. Her concurrence zeroed in on procedural fairness. She wanted the record to reflect that while the auction price baseline resolves the just compensation question, courts on remand should still scrutinize whether the government followed a fair process before seizing and selling the property. She flagged that door as still open.
And Justice Thomas concurred separately in Pung too. He concurred in part and in the judgment, joined by Gorsuch, except as to one footnote. Thomas wrote separately to plant a flag on originalist grounds. emphasizing that the historical understanding of just compensation in tax sale contexts, rooted in centuries of English and early American practice, fully settles the question without needing to reach some of the broader doctrinal moves the Alito majority made.
In other words, he agreed with the result but wanted a narrower, history-first path to get there.
And Justice Kagan authored one dissent, Exxon, one dissent, and appointed one. In Exxon, Kagan led the three liberals in arguing that the Helms-Burton Act did not clearly enough abrogate sovereign immunity on its own terms, that Congress needed to speak more explicitly. Sotomayor and Jackson joined her.
So, across all 5 cases, the liberal bloc authored a combined 5 separate opinions, 3 by Jackson, 1 by Sotomayor, 1 by Kagan. Jackson carried the heaviest load on the left.
Gorsuch quietly racked up the most opinion joining on the right, appearing in his own Landor majority, joining Sotomayor's Pung concurrence, and joining most of Thomas's Pung concurrence.
And that cross-ideological move in Pung? That tells the whole story about what made that 5th case different from the other 4.
Because in Pung, the ideological lines just dissolved.
Completely. While 4 straight cases split the court down the middle, conservatives on one side, liberals on the other, Pung drew nearly everybody together. Alito writing the majority, Sotomayor and Jackson joining it, then filing their own concurrence, then Thomas and Gorsuch layering on top of that.
No dissents. The same court that voted 6-3 4 times in a row couldn't find a single justice willing to break from the result in a Michigan property tax case. So 4 6-3s and one that unified almost the entire bench.
Let's run through all 5 opinions, starting with Blanche versus Lau. Blanche versus Lau centers on immigration law, specifically, what rights a lawful permanent resident keeps when returning to the United States after traveling abroad. Muk Choi Lau, a Chinese citizen, lived here as a lawful permanent resident since 2007. In May 2012, New Jersey charged him with trademark counterfeiting. He left temporarily for China. On June 15, 2012, he tried to re-enter the country at an airport. And that's where things got complicated.
Because normally, a returning lawful permanent resident doesn't have to reapply for admission, right?
Right. Under immigration law, someone in Lau's position typically returns as a resident, not as a newcomer seeking entry. But there's an exception. If that person committed a crime involving moral turpitude, which in plain English means a crime the law considers fundamentally dishonest or wrong, the government can treat them as someone applying for a brand new admission instead. Think of it like this. You left a party you already got invited to, you came back, and now the host checks your ID at the door and treats you like a stranger.
And the government did exactly that to Lau.
The border officer paroled Lau, let him physically enter the country without formally admitting him, pending resolution of his criminal case. After Lau pleaded guilty on June 24, 2013, the government started removal proceedings and charged him as an inadmissible applicant seeking entry for the first time, not as a deportable resident. Lau argued the border officer needed clear and convincing evidence he'd committed the crime before flipping his legal category.
The Second Circuit agreed with Lau. The Supreme Court, 6-3, reversed. Justice Thomas wrote the majority, joined by Roberts, Alito, Gorsuch, Kavanaugh, and Barrett. The court vacated the Second Circuit and remanded. Justice Jackson dissented, joined by Sotomayor and Kagan.
And then Cisco Systems versus Doe. Completely different scale.
Totally different. A group of Falun Gong practitioners, Chinese citizens, claimed the Chinese government persecuted them for their religious beliefs and that Cisco Systems built the surveillance technology China used to find and arrest them. They sued Cisco and 2 of its executives under 2 federal laws. The first, the Alien Tort Statute, the ATS, a law dating back to 1789 that gives federal courts jurisdiction over civil lawsuits brought by foreign citizens for violations of international law. The second, the Torture Victim Protection Act, the TVPA, which creates a cause of action specifically for torture and extrajudicial killing. The plaintiffs argued Cisco aided and abetted both.
So they argued Cisco handed the persecutors their tools.
That's the essence of it. And Justice Barrett, writing for 6 justices, joined by Roberts, Thomas, Alito, Gorsuch, and Kavanaugh, shut down both theories. On the ATS, courts cannot create new rights to sue for violations of international law. A 2004 case called Sosa versus Alvarez Machan, that stood for the idea that federal courts might create a narrow set of new claims under the ATS. The court now swept that framework off the table entirely.
And on the TVPA, Congress chose specific language, subjects, a person to torture, and that language targets the direct torturer, not someone who assisted from a distance. The Ninth Circuit got reversed. The case remanded.
But the separate opinions in Cisco splintered.
Good catch. Justice Jackson concurred in part and dissented in part. She agreed with the majority on the TVPA question, but broke from it on the ATS. Justice Kagan joined her. Then Justice Sotomayor filed a full dissent, joined by Kagan and Jackson on most parts. So even within the three-justice minority, not everyone spoke with one voice. That internal fragmentation signals the liberals don't fully agree on how far to push back on these human rights theories going forward.
All right, Exxon versus Cymex, Cuba, 60 years and over $1 billion. The backstory. In 1960, after Fidel Castro seized power, the Cuban government confiscated assets from foreign companies, including Exxon's oil refinery, terminals, packaging plants, and more than 100 service stations. Two Cuban state-owned companies, Union Cuba Petroleo, known as CUPET, and Corporación Cymex, stepped in and profited from those assets for 6 decades. Congress responded in 1996 by passing the Helms-Burton Act, which gave American nationals a private right to sue anyone who traffics in their confiscated Cuban property. Exxon sued in federal court, seeking more than $1 billion.
And Cuba's companies said, sovereign immunity, you can't touch us, sovereign immunity. That's the principle that a foreign nation and its government-owned entities generally can't get dragged into court in another country. Cuba's companies pointed to a U.S. law called the Foreign Sovereign Immunities Act, the FSIA, and argued Exxon needed to satisfy one of FSIA's specific exceptions to break through their immunity. The District Court and the D.C. Circuit agreed. The Supreme Court, 6-3, reversed.
Justice Kavanaugh wrote for the majority, the Helms-Burton Act itself strips that immunity. When Congress creates a cause of action that expressly applies against Cuban agencies and instrumentalities and defines person to include those entities, Congress abrogated their sovereign immunity right there in the statute. Exxon doesn't need to jump through the FSIA's hoops as well. Justice Kagan dissented, joined by Sotomayor and Jackson.
So Exxon gets its day in court, 60-plus years after Cuba seized its refineries.
60-plus years later. And now, Damon Landor versus the Louisiana Department of Corrections.
The prison haircut case.
The prison haircut case. Landor's Rastafarian faith requires him to keep his hair uncut. He claimed prison officers in Louisiana, fully aware of his religious convictions, forcibly shaved his head anyway. He sued the Louisiana Department of Corrections and the individual officers personally under RLUIPA, the Religious Land Use and Institutionalized Persons Act of 2000, a federal law that protects the religious freedom of incarcerated people and imposes those protections as conditions on any state prison system that accepts federal funds.
And Louisiana's prison system accepts federal money. LDOC agreed to answer RLUIPA suits as a condition of receiving that funding. But the individual officers argued, we personally never agreed to anything. Think of it this way. An employer signs a contract with the government to follow certain workplace rules. That contract binds the company. Not every individual employee who clocks in every day and never personally agreed to a thing.
And the court sided with the officers, 6-3. Justice Gorsuch wrote the majority. Roberts, Thomas, Alito, Kavanaugh, and Barrett joined. Under the Constitution's spending clause, Congress's power to attach conditions to federal money, those conditions bind whoever voluntarily accepted them. Individual prison officers never personally agreed to face RLUIPA lawsuits. Landor can't sue them personally for damages.
The Fifth Circuit's affirmance stands. Justice Jackson dissented, joined by Sotomayor and Kogan.
And then Pung, and the whole court basically walked in together.
Pretty close. The Pung family in Isabella County, Michigan, owed $2,241.93 in real property taxes. Local tax authorities started foreclosure proceedings and auctioned the family's home, a property assessed at $194,400 for tax purposes, and it sold for $76,008. The family argued that under the Fifth Amendment's takings clause, which requires the government to pay just compensation when it takes private property, they deserved not just the surplus from the auction above the tax debt, but compensation pegged to the full fair market value of the home.
So they said, our home sold cheap at a forced tax auction, not on the open market, and we deserve the real value.
Exactly. Justice Alito, writing for nearly the entire court, Roberts as Sotomayor, Kagan, Gorsuch, Kavanaugh, Barrett, and Jackson all joined, said no. For centuries, English and American law allowed governments to seize and sell property to collect unpaid taxes, return any surplus above the debt to the owner, and call that just compensation. The auction price, not the hypothetical market value, sets the baseline, the Sixth Circuit affirmed.
Justice Sotomayor filed a separate concurrence joined by Gorsuch and Jackson. Justice Thomas concurred in part, and in the judgment, joined by Gorsuch as to most of it. No one dissented.
So what does all of this actually mean?
After Blanche versus Lau, border officers now operate with broader discretion when a returning lawful permanent resident carries any criminal history. If you left this country and tried to come back with a pending or completed charge involving moral turpitude, the government can treat you as an admission seeker rather than a returning resident without clearing a heightened evidentiary hurdle at the border.
After Cisco versus Doe, federal courts closed the door on international human rights lawsuits against corporations. Companies that assist foreign governments in persecuting their own citizens no longer face ATS liability in U.S. courts. For global businesses operating in authoritarian countries, a major legal exposure disappears. For human rights advocates, a major legal tool disappears with it.
After Exxon versus Cymex, Americans whose Cuban property Castro's government confiscated after 1959 now hold a real path into court. Cuban government entities can no longer invoke sovereign immunity to block Helms-Burton Act claims. A 6-decade legal wall just came down.
After Landor versus Louisiana, individual employees at state agencies that accepted federal funding with conditions don't automatically face personal liability for violating those conditions. If you never personally agreed, you don't personally get sued. For prison inmates with religious freedom claims, that narrows the list of defendants.
And after Pung versus Isabella County, if you owe property taxes, your local government forecloses, and your home sells at a tax auction for less than market value, you get the surplus above the debt from the actual sale. The gap between auction price and appraised value, not your compensation. For every homeowner who ever worried about a tax lien, this case just drew the line.
And the through line across all five. Every conservative justice on the court authored a majority yesterday. Justice Thomas wrote Blanche. Justice Barrett wrote Cisco. Justice Kavanaugh wrote Exxon. Justice Gorsuch wrote Landor. Justice Alito wrote Pung.
Chief Justice Roberts joined every single majority without authoring one, and the liberal bloc, Sotomayor, Kagan, and Jackson, dissented together 4 times in a row, then crossed over to join the majority in a property rights case about a Michigan family and a $2,000 tax bill.
$1 billion Cuban standoff and a $2,241 tax bill on the same day. That's this court.
The term closer always tells you something about where the justices stand.
This one told you everything. And remember, we'll drop individual full-length episodes on each of these 5 opinions, so you get the complete story on every case. Plus, the court may release additional opinions tomorrow, June 25th. Keep an eye on the feed. If opinions drop, we'll cover them.
Subscribe so you don't miss a thing, because this term still might not be finished. Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about any of these cases, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
5 cases, 1 episode, 0 boring moments, and we dropped it the morning after. Who else does that?
Nobody. Talk to you soon.